Good day, everyone, and welcome to the BVI Finance Breakfast Forum. We are pleased to have you join us for today's discussion on sanctions guidelines. As a British overseas territory, the BVI implements all international sanctions extended through the United Kingdom legislative action. Sanctions compliance is critical for financial institutions, designated non-financial businesses and professions, and nonprofit organizations, as well as for individuals and other regulated entities within the BVI. Today's session will provide essential insights into meeting financial sanctions obligations, including guidance on licensing and compliance consideration. And we are delighted to welcome today's guest speaker, Ms. Kisha Frett, the Sanctions Coordinator at the Virgin Islands Sanction Unit within the Attorney General's Chambers. With over 12 years of experience as a practicing attorney at law, Ms. Frett is called to the Bar of England and Wales, as well as the Bar for the Eastern Caribbean Supreme Court here in the BVI. She has worked extensively across both the public and private sectors, tackling a broad range of legal matters. In her current role, she leads the Virgin Islands Sanctions Unit, ensuring that sanctions obligations are effectively understood and implemented in the jurisdiction. We encourage all attendees to submit your questions in the Q&A box, and following Ms. Frett's presentation, we will take time to discuss and address your questions. Thank you so much for joining us for this today's session on sanctions guidelines, and we look forward to an engaging and informative discussion with Ms. Kisha Frett. I now turn it over to her for her presentation. Ms. Frett?
Thank you very much, Ms. Donovan, for the warm welcome. It is indeed a pleasure to be here with you all to speak about sanctions compliance. This is my first time presenting at this forum, and indeed, this is the first time that I am presenting since the official delegation of powers from the governor to the Attorney General. So welcome and good morning from the Virgin Islands Sanctions Unit. As mentioned, I will be speaking today about some key updates that took place since the last outreach session, key reminders, and best practices. Firstly, I will be covering the delegation of powers. I will be speaking about two particular legislative updates. There have been updates to the sanctions guidelines as well, so I will be speaking about that. And I will then share some best practices and go through a few case studies. The powers of the governor concerning sanctions was delegated to the Attorney General in November of 2024. What does that mean? The governor remains the competent authority responsible for sanctions implementation and still have the powers to grant, vary, revoke licenses, receive compliance reports, and publish certain lists. But as mentioned, some of these powers have been delegated to the Attorney General. And as such, the Attorney General has the power to receive and process license applications for submission to the governor with the consent of the Secretary of State, to receive and process compliance reporting forms. The Attorney General is the authorized officer for the purposes of implementing, monitoring compliance with, and detection of sanctions. Also, within the parameters of the Attorney General's powers is the authority to implement and enforce general licenses. We also will be coordinating the publication of the overseas territory sanctions orders. So all the work of the Attorney General concerning sanctions will be done through the Virgin Islands Sanctions Unit. Other powers.
Can you just increase the volume a little bit, please? Thank you.
No problem. Other powers that were delegated concerning the publication of list of designated persons were delegated to the Financial Investigation Agency and the Financial Services Commission. So I would encourage persons to continually look at the website for the FIA and the FSC for updates on designated persons. Turning then to the key legislative updates. A finding outlined in a mutual evaluation report for the Virgin Islands was that as it related to targeted financial sanctions for terrorism and terrorist financing and proliferation financing, the mens rea element was too narrow and did not align with FATF standards. Amendments were made to address these deficiencies and is part of the Virgin Islands' effort to maintain high global standards in AML, combating the financing of terrorism and terrorist financing and proliferation financing. So if we look to the Proliferation Prohibition Act, there is now a strict prohibition to deal with assets owned and controlled, held directly or indirectly by or on behalf of a designated person. The prohibition also extends to making an asset available directly or indirectly, wholly or jointly. Any knowledge of dealing with or attempted dealing with an asset needs to be reported to the FIA. Additionally, there was a threshold of $10,000 in terms of financial transactions involving a designated person. However, that threshold has been removed. Any financial transaction of any amount needs to be reported. Powers of the FIA have also been extended concerning the issuance of guidelines under the PFPA. As it pertains to the Counter-Terrorism Act of 2021, there were some new definitions inserted concerning designated terrorist entity and relevant Security Council resolutions. Also, there was clarity given as to the applicability of the Counter-Terrorism Act as it pertains to terrorist and terrorist financing activities and not proliferation financing activities unless those activities concern a terrorist or terrorist financing element. What the amendments also did was address the mens rea deficiency, as I spoke to you about. A person now shall not be reckless as to whether a designated terrorist entity is dealing with funds or economic resources. A person shall not be reckless as to whether a person is making the funds or financial services available to a designated terrorist entity. Shall not be reckless as to whether or not a person is making the funds or financial services available for the benefit of a designated terrorist entity. In addition, you must be reminded that failure to freeze assets or economic resources of the designated terrorist entity is an offense. There have been an amendment concerning the governor's power to grant licenses regarding United Nations Security Council Resolution 1373. That allows for basic expenses to be paid, reasonable professional fees to be paid, or extraordinary expenses. A deficiency that was also found in the Act was that we know that assets need to be frozen immediately, but when it came to delisting or unfreezing of assets, there was found that there's a delay in communication of that information. So it is now a requirement that the FIA and the FSC immediately communicates delisting and unfreezing of assets to their supervised institutions. Now we're hearing a lot about sanctions. And the question might be asked, who should comply with sanctions? Sanctions is whose business? As it pertains to the UN sanctions and the UK sanctions that have been extended to the Virgin Islands, any person in the Virgin Islands needs to comply. A person who is a British citizen or a British overseas territory citizen. Any body incorporated or constituted under the law of the territory, and any person on board a ship or aircraft that is registered in the territory. Additionally, UK financial sanctions apply to all persons within the territory and to all UK citizens wherever they are in the world. Therefore, all individuals and legal entities in or undertaking activities within the Virgin Islands must comply with UN and UK financial sanctions that are in force in the Virgin Islands. As mentioned, the sanctions guidelines were amended and the new amended sanctions guidelines were published on December 31st, 2024. I wish to highlight the asset freezing requirements pursuant to the relevant sanctions legislation. You are prohibited from carrying out certain activities, including dealing with funds or economic resources belonging to or owned, held, or controlled by a designated person. Prohibited from making any funds, economic resources, financial, or other related services available directly or indirectly, wholly or jointly to or for the benefit of designated persons or entities, or behaving in a manner that is non-compliant with the requirements under the financial sanctions legislation, if financial sanctions apply. Now, I would wish to break your asset freezing requirements down in sections. First, I will deal with the UK sanctions regulations and the UK sanctions regime. If you know or have reasonable cause to suspect that you are in possession or control or otherwise dealing with the funds or economic resources owned, held, and controlled by a designated person, you must freeze them immediately. You must not deal with them or make them available to or for the benefit of a designated person unless there's an exception in the legislation that applies or a license has been issued by the governor. In any event, you must report the activity to the sanctions unit using a compliance reporting form. There are various definitions that can be found within the legislation for the UK sanctions regulations, and I encourage you to be familiar with those definitions. For example, funds. Funds includes cash, checks, monies in account. Economic resources, that includes property, developed, undeveloped, vehicles, antiques. Dealing with assets concern it includes transferring, moving, altering, or using that asset in a way that results in change of ownership or location. As it pertains to asset freeze requirements under the Proliferation Financing Prohibition Act, there is a strict prohibition on dealing with assets of designated persons. You must immediately freeze and report. For assets under the Counter-Terrorism Act, if you are in possession of funds or economic resources known or suspected to be dealt with by a designated person, those assets should be frozen without delay and without providing notice. I must remind you of the change to the legislation, so therefore you must not be reckless as to whether or not a designated person is dealing with the asset. Considering the above, I must remind you, therefore, review the relevant legislation for the definitions and meanings. Review the guidance that has been issued. Guidance in the sanctions guidelines or also guidance published by the UK or even by OFSI. And when in doubt, seek independent legal advice. Reporting under the UK regulations and the orders in council. Who must report? A relevant firm, relevant institution, and involved persons must report. You are reporting to the Attorney General via the Sanctions Unit. What are you reporting? You're reporting known or suspected designated persons that might be your client. You are reporting regarding breaches and suspected breaches of financial sanctions. You are reporting regarding frozen funds, economic resources, and you must include details of the funds or economic resources that are being held, the amount, the quantity, the nature. You must also report regarding credits to frozen accounts. Reports to the sanctions unit would be by way of the compliance reporting form. We encourage you to please properly fill out the forms. There are also compliance reporting obligations with respect to licenses, whether it's specific licenses granted by the governor or general licenses. The general licenses do have their separate compliance reporting forms, and we wish for you to be aware of that. Please note that failure to report when you should report is a breach of the regulations. And I must interject here with an observation that we have seen. There are cases where persons have not reported utilizing a compliance reporting form or have not reported, period. And they might then submit a license application seeking permission to receive payment, for example, from the client who's a DP. But then the question is, you have a client as a designated person, but you have not filed a compliance report. And here you are filing a license application. Or the converse might be true. A person might file a compliance reporting form, and having analyzed the information in the compliance reporting form, you see that there was activity that happened previously that required a license, and we do not have license for those individuals, and therefore breaches are discovered. We therefore encourage persons to please be familiar with the relevant regulations and your obligations to report so that you are not found to be in breach. As highlighted in the example that I just gave regarding payments, if you're receiving payments from a designated person, a payment is made on behalf of a designated person, or you're receiving reimbursement, you need to make a report and in cases, seek a license. Under the UK regulations, there are additional reporting requirements for relevant firms regarding prohibited persons. This is not just designated persons, but prohibited persons. Prohibited persons here are in relation to the Russia regime. And according to Regulation 18A1 of the Russia regulations, it includes the Central Bank of the Russian Federation, the National Wealth Fund of the Russian Federation, the Ministry of Finance of the Russian Federation, a person owned or controlled directly by those entities. Your obligation is to report to the Attorney General regarding any financial sanctions matters. And this obligation is in addition to any other obligation that you might have under the AML, CFT, CPF obligations that may apply to you. For example, you might just need to submit a suspicious transaction report to the FIA as well as a compliance reporting form. I move then to reporting under the Counter-Terrorism Act. Who needs to report? A reporting entity has the meaning in Section 61(3) of the Act. That is, a person that is engaged in relevant business as defined under the AML regulations, non-financial business that is designated, non-profit organization within the meaning of Section 2 of the Non-Profit Organizations Act. Any other person that is required to comply with the CTA, the Proceeds of Criminal Conduct Act, the Anti-Money Laundering Regulations, the Code of Practice, and any other guideline or practice direction that has been issued by the Financial Services Commission or the FIA. Relevant business here means banking business or trust business, insurance business, and the business of company management. Persons who also need to report under the CTA includes a person regulated by the FSC by virtue of the FSC Act, and non-financial designated business designated under the non-financial business designation notice. Reporting under the CTA has a dual component. I must stress that there's a dual component under the CTA. There's reporting to the governor and there's reporting to the FIA. When do you need to report to the governor? A relevant institution, as defined in Schedule 4 of the CTA, indicates that you should report regarding your knowledge or suspicion of designated terrorist entities, information concerning offenses under Sections 5, 7 to 9, and 12 to 31 of the CTA. You must provide details of the nature and amount of funds held by the designated terrorist customers, any actions taken under the CTA prohibitions. You must provide the details of the funds, economic resources, any details of transactions and attempted transactions. Also, credits to any frozen accounts. Reports to the governor through the sanctions unit should be by way of a compliance reporting form, and you should report without delay. Reporting then to the FIA, a relevant firm or reporting entity shall report actions taken in respect of a suspected breach of sanctions by a designated person, including assets frozen and unfrozen, suspicious activities or transactions related to terrorist financing and terrorist acts, attempted transactions, details of property in possession or control that is suspected to be owned or controlled by a designated terrorist entity. This report to the FIA should be done within 5 working days maximum. You will be reporting to the FIA utilizing the suspicious activity report or suspicious transaction reporting form. Remember, any matter concerning sanctions and targeted financial sanctions under the CTA would also require you to report to the governor. Under the PFPA, then, the Proliferation Financing Prohibition Act, you are reporting to the FIA, and you're reporting once you hold an asset that is owned, controlled, held for on behalf of a designated person. You are supposed to report regarding the attempted transactions. And remember, I spoke about the removal of the threshold of $10,000. You are supposed to report regarding accounts opened or attempted to be opened, companies or structures that could evade the PFPA prohibitions. Again, reporting should be within a reasonable time and no longer than 5 working days. Just a reminder regarding, regarding the dual reporting so that it is clear, because we do have instances where persons are reporting to one entity and not reporting to the other, and you would find yourself to be in breach of the legislation. When dealing with terrorist financing matters, report to both the sanctions unit and the FIA. Different forms might apply. As mentioned, the compliance reporting form for the sanctions unit and the suspicious activity report for the FIA. For sanctions breaches for UN or UK targeted financial sanctions, the primary report is to the sanctions unit. In addition, report using the suspicious activity report to the FIA under the AML and CFT obligations that you might have. For suspicious transaction reports, these go to the FIA, and if it is sanctions related, please also report to the sanctions unit. Again, we must stress that if you are unsure of your reporting obligations, please do seek independent legal advice. What then are the consequences of your failure to report or poor reporting? It is a breach of law, first of all, where you are supposed to report and you have not reported. It can result in criminal prosecution, other fines, and penalties. Furthermore, it is just simply bad for business. The negative effects will eventually be felt. It inhibits the jurisdictional development. Without the ability to review and assess the information and what is going on in the jurisdiction, we will not be able to properly get risk assessments conducted. We wouldn't be able to then develop the key laws and policies and procedures that are needed to be developed in order to stamp out this illicit activity. It prevents the jurisdiction from being able to effectively defend and guard itself against malign actors. Furthermore, failure to report and poor reporting prevents the jurisdiction from meeting its international obligations, which may result in negative reviews, assessments, ratings, and listings. What then should you do? You need to implement risk-based policies and procedures. It doesn't make sense to have policies and procedures in place that are not being utilized or that are outdated. Sanctions is a space that is completely subject to change at any given moment. It's continuously changing, and therefore policies and procedures need to be continually reviewed and changed to align with what is present and the present risks that are being faced. You must continuously conduct sanction screening and monitoring. Review the list of countries and persons that have been designated. There's the UK sanctions list, and there's also OFCE's consolidated sanctions list. These lists are available to be subscribed to, and I encourage persons to subscribe to these lists so that they get notifications immediately. Conduct risk assessments. Develop a risk profile to determine the potential risks that an applicant for a business or customer poses and the best way to manage and mitigate those risks. Train staff continuously. While we might have training sessions and outreach sessions as put on by the sanctions unit and any other competent authority, the onus is also on the businesses to train your staff and to train your staff continuously. Know your customer. Conduct your due diligence, and in some cases, enhance the diligence. Know the activity type, the transactions. Be familiar with the transactions patterns of your customer so that you know when something requires greater scrutiny. Conduct, enhance due diligence in line with your risk profile and also any other changes in your clients or the transaction. Know your customer's customer. Keep records. Keep records of your reports. Keep records of any sanction screenings that you did, any matches, any fuzzy matches, and what you did. Seek independent legal advice. I cannot stress that enough. In the few minutes left, I want to take a closer look, into proliferation financing risk and typologies and what we have seen concerning BVI companies. And hopefully, after going through those typologies, I will be able to share with you some key strategies to guard against proliferation financing. And just to put things in context, proliferation financing involves the movement of funds and financial services that contribute to the development and spread of weapons of mass destruction. You play a critical role in identifying, preventing, and reporting PF activities. In this typology, we have the use of BVI companies, as they would say, as shell companies in maritime sanctions evasion. You have a BVI company that owns a vessel, and there are frequent changes in vessel ownership and management without updating the international maritime databases. You have companies that are serving as nominal owners, and therefore you cannot tell the true ownership through the layering structures of the companies. And this might involve multiple jurisdictions as well. You will find also that these companies do not comply with reporting obligations in maritime databases or any other reporting obligation. Sorry. In this case, you had the Bonvoy 3, which is a vessel. This vessel was reported to have delivered refined petroleum to the DPRK in 2019 and 2020. The vessel was previously managed by a company called Shore Metro, but then the ownership was changed to Faith Trade Group, which is a BVI company. There was scrutiny on a previous UN report in 2020 regarding the ownership of the vessel, and then the ownership was then changed to another company based in Hong Kong. The pattern of changes in ownership was flagged as a red flag for sanctions evasion. Utilizing this same information, we have a different typology where the companies involved in suspicious financial transactions. Again, the entity was linked to sanctions violating activities by having transactions structured to multiple offshore accounts, making it difficult to trace. These transactions involved vessels again carrying petroleum to DPRK. And it was found that they were intentionally hiding who the true beneficial ownership are for the company. What we see here, and I must stress this because we are getting articles over and over and over again regarding these BVI companies that are owning vessels and that are involved in these ship transfer tactics. What are we doing about it and what can we do about it is the question that requires answers. The report highlights that there are clear PF risks associated with BVI companies, particularly in the maritime sector, and the use of these companies to conduct fraudulent identity transmissions and facilitate illicit financial transactions demonstrate the vulnerabilities that require urgent attention. So, what can we do? You can enhance and strengthen your due diligence. We can increase international cooperation to help mitigate against some of these risks that we are seeing with these typologies. For more information about those two typologies, you can see the UN Panel of Expert Report 777 of 2021. These UN Panel of Experts reports are available on the UN website. I just wish to quickly go through another one where we have companies operating in trade-based money laundering, again through the maritime trade. The report outlined that beware companies are intermediaries in complex shipping and trade transactions that involve the movement of illicit funds. We see false invoicing, over and under invoicing tactics that are used to disguise the true nature of transactions. There are sudden spikes in activity involving the BVI entities with no historical records of maritime trade. And this is where I spoke about being familiar with your client activity to know when there is something unusual and when it's usual activity. Changes in assets and asset name, changes in company names and registration numbers and operators. Companies are using in care of addresses. When you search, you can't find any information about the company's business or operations. Again, the risk is there for BVI companies to be exploited for laundering illicit trade proceeds. This last case concerned a company called Spring Gain International Limited. Information about this can be found in the UN Panel of Export Report 211 of 2021. Here we have a BVI company that is being used. It is identified as a registered owner, ship manager, and operator of a vessel called NPing. The NPing was said to be engaged in illicit petroleum shipments, which were violating UN Security Council sanctions against North Korea. It was said that the vessel was operating under different flags and identities, and in some cases, there was no information regarding the flag. The vessel was said to be involved in ship-to-ship transfers, circumventing sanctions. And what you would find also at the ship is that the ships would go into certain locations and they would disappear off the radar. And they would disappear off the radar for days on end, and then suddenly pop up in a different location. Based on the commodities that are being transported and also the locations, it is said that these ships and the activity are most likely to be sanctioned activity. False documentation and deceptive practices, as I mentioned, they're turning off the automatic identification system signals so you don't know where they are and what they're doing. What we are seeing from these typologies and what the image is showing is that there might just be regulatory gaps as it pertains to tracking and knowing what these companies are doing, the limited information that you would find concerning company ownership. We see here as well, my computer is doing what it wants. We see here as well that these companies, once they are found out, they're suddenly dissolved, for example. But I have seen cases where companies are dissolved on record, but then you are still seeing news articles about, the participation of vessels owned by these same companies in sanctions evasion and sanction activity. We see then that the vessels that are supposedly owned by these BVI companies are still operating, um, and they're operating without proper ownership. What does that mean for the BVI? What does that mean for the jurisdiction? What can we do to mitigate against proliferation financing? Strengthen your due diligence. Implement enhanced due diligence where you're dealing with high-risk customers, particularly those in industries that are vulnerable to PF. Again, the maritime industry. Screen your clients and beneficial owners against the sanctions list. Conduct periodic risk assessments to identify your customers, business relationships, and transactions with PF indicators. Conduct transaction monitoring and screening. Flag transactions that involve dual-use goods. Review transactions of companies that are registered in the jurisdiction for weak AML CFT controls. Have enhanced screening for shipping and trade finance. Require full disclosure of end-to-end user trade finance transactions. Pay keen attention to maritime red flags. Ships that frequently change their names and change flags. Ships that disable their automatic identification system and conceal movements. Have background checks conducted on shipping companies, freight forwarders, maritime insurers to avoid dealing with front companies. Strengthen governance and internal controls. Establish an internal PF risk assessment framework that are tailored to your sector. Train compliance officers and frontline staff on TF typologies, red flags, or reporting obligations. As mentioned, many of the typologies that I've seen, you can extract from the UN panel of experts reports and train your staff on it. Ensure that there is senior management oversight of high-risk clients and transactions. Implement strict beneficial ownership transparency measures. Ensure that you know who the beneficial owners are of the companies that you are providing services for. Conduct regular review of the ownership structures. The financial institutions, regulators, and the corporate service providers in the BVI should work together to detect and prevent financial crimes, reduce our exposure to risk, and enhance the Virgin Islands' reputation as a compliant financial jurisdiction. We want you to do your part. Again, I cannot stress enough. Please subscribe to the list to get updates regarding any changes from the UN, UK, and FATF. File your reports, your compliance reports, your suspicious transaction reports. Cooperate with law enforcement and any regulatory authority to provide intelligent on suspicious transactions, and ensure that there are clear protocols to escalate matters where PF cases are concerned. I conclude with just a reminder that the governor is still the competent authority for financial sanctions implementation. Powers have been delegated to the Attorney General, to the FSC, and the FIA. The two key pieces of legislation concerning targeted financial sanctions in the Virgin Islands have been amended. Please review those pieces of legislation. These pieces of legislation have been reviewed, as mentioned, to bolster and strengthen the Virgin Islands AML, CFT, and CPF framework. So we need you to implement robust systems, be vigilant against evasion, freeze assets, report as required, and seek legal advice. Stay informed and be proactive. And when we all do that, we can collectively strengthen the Virgin Islands' financial integrity and uphold its reputation as a compliant financial jurisdiction. For more information, you can contact us at sanctions@gov.vg. Our telephone number is 468-2960. I hope that the information that I provided was useful. I know this is a breakfast session, but I believe that might have been a whole meal breakfast, lunch, and dinner. Sanctions is a lot to unpack, and we do intend to have separate targeted sessions on certain topics and towards certain sectors so that we can really get into our sanctions compliance and the information that need to be shared and understood by all.
Ms. Frett,
But
thank
that
you.
is it for me this morning.
Yes,
Thank you.
thank you so much for that. As you said, it's a lot to unpack, and you certainly have to provide, I think, training, specific training for the industry with regards to unpacking this whole sanctions regime. What are some of the biggest misconceptions that you're seeing? You outlined certain typologies, but what are some of the biggest misconceptions that you're seeing in the BVI with regards to sanctions and sanctions obligations?
I believe that persons think that the individual, the regular person, believe that sanctions do not apply to them. It is left for the firms, it is left for the regulators to deal with. And that is not true. Sanctions is everyone's business. And as such, when it comes to the reporting, we're not seeing the amount of reports that we should be seeing. We're not seeing the information in the reports that we should be seeing in terms of public filling out the reports. And that shows that persons are not understanding their obligations. They're not understanding that sanctions is everyone's business. With respect to some of the typologies that we're seeing, you might have situations where persons believe that, okay, um, I have a BVI company or I service a BVI company, but they don't operate here. And therefore, I don't know what they're doing. What they're doing, it's basically none of my business to a certain extent or a certain degree. And so they're not keeping track of what this company is doing. And as a result, you have instances as shown in these typologies where assets are being owned by BVI companies. Yes, it's not taking place in BVI waters or, within the BVI itself, but you have companies that are behaving in a way that are breaching international obligations, breaching sanctions. And the question then is, what are the companies registered agents doing? What reports did they file? What have they seen? What information have they shared? What are the regulators doing? We all have a part to play to ensure that sanctions breaches are not taking place, or that the BVI companies are not using in a way that they should not be used.
So what I'm hearing you say is there is a monitoring obligation on the part of practitioners to know what the companies that they're agents for are doing.
There is a certain level of monitoring that needs to take place, yes, because it's not a matter of incorporating a company, providing copy of an M&A director's certificate when they need, providing certain accountancy services or legal services to companies, and not being fully aware of what the transaction involves. So this is why we have mentioned that you need to be familiar with what the transactions activity is, what it involves, does it involve PF or TF? Do you see something that is suspicious? Um, you know, this information needs to be shared with the relevant authority. Monitoring is not just the regulators, the FIA, the FSC, or even the sanctions unit. Everyone has a part to play in monitoring.
So how do you deal with a situation where a BVI company sold its sanctioned Russian investments to another BVI company or another company who is not a designated person?
This is a transaction regarding a person that is not a designated person.
That's what it says.
So the reporting obligations concern designated persons. However, if the transaction revolves around a prohibited person, as I mentioned, for example, for the Russian regulations, then there will still be uh, a responsibility to report. But without further details, I wouldn't be able to specifically say what that person would need to do. I would need to see the information.
Okay. And yes, to answer all the questions, we will be sharing the presentation from Ms. Frett's slides. So those will be available to everyone who's on today's session. And the next question is, you outlined that the governor's office is still the competent authority for sanctions, but there has been
Correct.
designated to the sanctions unit, the FIA, the FSC, and there are reporting obligations to various entities. Can you just briefly go through the competent authority, the delegated authority to the various agencies, and the reporting obligations? Just briefly.
So the powers that were delegated to the Attorney General concerns receiving license applications and processing them, receiving compliance reports and processing them. We are responsible for any outreach, publication, and issuance of general licenses, publication of the orders in council. As it pertains to the licenses, the governor, as mentioned, is still the competent authority, so the governor signs off on these licenses with the approval of the Secretary of State. So, in terms of processes, a license application comes in, it is vetted, it is processed, um, it goes to the governor for decision. If it is a decision for the license to be approved, it goes up to the Secretary of State for approval, and then comes back down. The governor signs, and then it is issued. Um, in terms of the FIA and the FSC, they were delegated powers to publish lists of designated persons and keep the list up to date. In addition to that, as mentioned, under the CTA and the PFPA, there are reporting obligations to report to the FIA regarding suspicious activity and suspicious transactions. Those reports need to go to the FIA. But once it concerns sanctions as well, the compliance reporting form needs to go to the governor. In addition to that, I believe in 2023, there were powers delegated previously to FIA as an authorized person to request information and request documents as it pertains to sanctions investigations. So, if a person files a compliance reporting form, for example, and there's a sanctions, um, suspected sanctions, breach, the FIA is authorized to investigate regarding those potential breaches or breaches and request information in that respect.
How successful have you been in terms of enforcement actions or penalties applied? And what are the enforcement actions or penalties?
Well, right now, once there's a breach of a sanction provision, there's the criminal escalation route where a person can be prosecuted, um, fines can be imposed, or imprisonment. There have not has well, there are active investigations ongoing, and so I cannot speak about that. But what we have found, and this is clear in the UK as well, that prosecuting through the criminal um, avenue might prove to be difficult. And as such, the UK, for example, has implemented civil monetary penalties where persons can simply just be fined. They also have disclosure, which they call name and shame, which they can publicize persons or entities that have breached sanctions. Um, but in terms of the Virgin Islands, we have not. we have not penalized any person as yet or have had any full-blown criminal prosecutions with respect to sanctions breaches.
With respect to getting all this information consolidated, will there be a designated sanctions unit website where all this information will be consolidated so people can access it readily? Because based on what you've said, it's disparate places to find the information, whether it's the FSC, the FIA, the governors, the UK sanctions unit, I forgot the name of it. But there are all these different places to get information. So are you going to consolidate all this information to have it readily accessible to practitioners?
So the short answer to that is yes. We are currently working on a website for the Virgin Islands Sanctions Unit, and it is intended that that website can be utilized as a resource for sanctions information. Um, Guidance would be on there, legislation would be on there, links to relevant guidance that the UK might have that would be relevant would be on there. We would be periodically putting information or grab bites, as I call it, on various topics concerning sanctions. Um, any outreach session or any information from outreach session would be plugged in there as well, whether it's slides, whether it's handouts. That information would be on there. And of course, outreach is something that we will be continuously doing. So we would have continuous sessions with industry, with particular sectors and various topics, and any recordings of those would hopefully be on the website.
Okay, we have another question. A BVI company with a Russian UBO who is resident in Russia but is not a designated person, can we deal with them or do we need to apply under the license?
Um, I believe that with respect to specific queries, we will need to have all the details before we can possibly give an indication as to whether or not the person might need a license. So I wouldn't be able to say definitively what they would need to do without really getting an appreciation of all the facts. Because, as I mentioned, the various pieces of legislation are expansive. You might have a particular provision here that says, okay, the person needs to be designated, or I should say, you shouldn't deal with designated person. But then again, as I mentioned, there are provisions in legislation concerning prohibited persons. So we would need to get an appreciation of all the facts before we can indicate whether or not that person requires a license. And of course, if persons are unsure of the obligation, they should seek independent legal advice.
Can a receiver be paid under the general license, under the grounds of expenses?
I would have to double check the provisions of the general license to give that indication. So perhaps that person can leave the question and I can revert with that answer.
If funds are being held in an account by a law firm and the purpose of those funds are to handle legal matters that commence and remain ongoing before the law firm's client became a designated person, does the financial institution have a reporting obligation to the sanctions unit, noting that the designated person is not the financial institution's client?
So the answer to that question is yes. The The requirement to report regarding funds on account for designated persons applies to financial institutions. So yes, they have an obligation to report, and also the law firm who has that client has an obligation to report that they do have a designated person as a client and that they have funds.
I don't see any more questions. I think there's a lot to unpack, and I know Ms. Frett is going to make herself available for the training and for the information, as well as she continuously said, seek legal advice to ensure that you're compliant with all the sanctions obligation and to ensure that the jurisdiction is not compromised and put at risk of non-compliance. I want to thank Ms. Kisha Frett for joining us here for this BVI Finance Breakfast Forum. We are pleased to help to be part of the education campaign from the Virgin Islands Sanctions Unit. And we're going to welcome her back again to go into more details on how we can be more compliant with our sanctions obligation. I would like to say that we will make the slides available for those of you who are looking, and we will encourage us as much as possible to get the information from the sources that she has outlined, including her office, the FSC, the FIE, as well as the UK sanctions office, and make sure that we are doing all that we are required to do as a jurisdiction to ensure compliance. Ms. Frett, is there anything you would like to close and say before we close off?
I just wish to thank persons who attended, for your attention. I hope that the information that was shared is useful. Again, please ensure that you're familiar with the relevant sanctions regulations that apply in your circumstances. Review the sanctions guidelines which we have recently issued, as I mentioned. The copy of the guidelines can be found on FSC and FIA's website and will be found on the Virgin Islands Sanctions Unit website once it's up and running. I encourage persons to please adhere to your sanctions compliance requirements, because at the end of the day, it's not just about yourself or the firm, but it's about the jurisdiction. Thank you.
Okay, thank you so much. This has been another BVI Finance Breakfast Forum. We've been talking to the sanctions coordinator, Ms. Kisha Frett, regarding the sanctions guidelines and all the obligations that we are required to do as a jurisdiction. Again, thank you so much for joining us, and do have a pleasant day.